Thank you so much for coming.
Yeah.
It's not a requirement, but we would urge you to move forward because the screen is tiny. Um, so it might be hard to see if you're in the back. Well, thank you all so much for being here today and coming to Denver Startup Week. We are Jason and Amanda from Milgram and Dascom, which is a small law firm here in Denver. We do all sorts of corporate law, litigation, employment, intellectual property, and we've got a series of presentations this week talking about businesses. Business foundations. We are the session 2 of 3, and we are here to talk about third-party contracts. I'm going to give Denver Startup Week's little intro before we start. So thank you for joining us at the 11th Annual Denver Startup Week. Thank you to our title sponsors, Amazon, Capital One Cafe, Dell for Startups, and the Downtown Denver Partnerships. This session is part of the Designer Track, which is sponsored by the Public Works and Battery 621. And it's one of 8 programming tracks aimed at supporting the entire entrepreneurial team. By attending this session, you're agreeing to follow our code of conduct, as well as to being photographed or recorded on video. Be sure to share your experience at this session online using hashtag #DenStartupWeek and Milgram and Dascom. So as I said, I'm Amanda Milgram. I am a litigator at the firm, and I deal with a lot of business disputes and issues around different contract provisions that are being disputed. And my colleague?
And I'm Jason Fisher. I'm with the corporate group, and so I think of myself as working on the front end of contracts, drafting and negotiating them, and trying to avoid litigation so that Amanda doesn't have to deal with some of those tough issues.
And so together we're going to sort of go back and forth today and talk about different provisions that we think are really critical for folks to know about when starting and running a company, and how to avoid litigation, hopefully, so that you never have to work with me. Because we're lawyers, we have to say this disclaimer. This is not legal advice, and there is no attorney-client relationship being formed here. Obviously, please reach out if you have questions. And as we're going along, this is a pretty small group. If you guys have questions as we're going, just raise your hand. We're happy for you to just hop in and ask a question as we go instead of waiting till the end.
All right. And so through our presentation, we're going to look at 3 different types of contracts, and we're going to walk through some various provisions in those contracts, discuss what they are, why they're there, just to help you guys better understand as you guys are reading through your own contracts. And so the contracts we're going to look at is a co-manufacturing agreement, and that is for the production of physical goods. In this instance, this contract was for the production of handheld meat pies, so it was a food production. Then we're going to take a look at a development agreement for the development of software. That is a master service agreement, so it's sort of an ongoing obligation where there are many different statements of work underneath that, so we'll kind of discuss that structure as well. And then we're going to talk about a confidentiality and proprietary rights assignment agreement, also called a PIAA. And that is important for any startup business when engaging a third party and you're going to discuss some of that confidential information or trade secret. You always want to protect that, as that's that's usually one of the most valuable assets that a startup business has.
We're also going to be discussing the cost of litigating contract provisions and how to avoid them. So as Jason is moving along through these contracts, I'll be hopping in at points to discuss certain provisions that I've seen be litigated more frequently and how some tips to avoid it. As you guys, I'm sure you know, litigation is extremely expensive, both in terms of monetary cost, but also business disruption, how much energy it takes for you and your employees to actually deal with the litigation. So we're going to talk about a couple overarching themes throughout today. One is anticipating and addressing worst case scenarios. Folks often want to avoid those and just not talk about them, but you really want to address each and every one in your contract so that if it does come up, you have a way to move through it that's outside of court. You also want to leave nothing to chance, and this means defining as many terms and procedures as possible. And you'll see Jason go through this over and over again with different provisions here today. Defining terms, let's make sure all the parties are on the same page about what things mean and how to work through them. And then finally, we're going to talk about some limiting the advantages of litigation, for example, by capping damages, and some ways things you could put in your contract to make sure litigation doesn't happen. Let's get started.
So diving right in, just a bit about the structure of legal agreements. So here, this is from the co-manufacturing agreement. agreements generally start off with recitals. That's what these are here. This is a context-setting tool. So recitals are not legally binding unless they are expressly stated so, but we really just want to be upfront about why we are here. Why are these parties meeting with each other? Why are they going to agree to do something? And so here we've got that the co-manufacturer is in the business of producing these goods. We've got a buyer that is willing to purchase that service to produce those goods, and so that's why they're here. That's why we're going to agree on these terms. And then right off of the bat, we're going to turn those recitals into a legal obligation. So again, we're just context setting here. Finished products, what are we doing? What legal obligation do we have? And so here we have the co-manufacturer is agreeing that they have the capacity and the ability, and they are going to produce these finished products for the buyer. And as Amanda mentioned, we're defining terms, very important throughout. So here we have finished products as a defined term. We want to be clear on the definitions of things so that all the parties are on the same page. And then again, specifications, so we're going to get a little deeper. We want them to produce goods, but we want to be very clear on how they are producing the goods. We want to say explicitly what they're going to do. And so here, this is for a food, and so there's a recipe that's involved. And so we want them to produce them to our specifications. And so we're going to solidify that with a provision stating expressly what they're going to do. So again, these are just kind of context setting, general structure of the agreement. And we're going to talk about some more legalese provisions here in a bit as well. And so product inspection and rejection. When you're dealing with the production of physical goods, if you're going to receive anything from anybody else, you want to be clear on what the terms are for if that good that you're receiving is not up to standards. So we set those specifications. If they don't meet it, we need to state explicitly what we're going to do, how we accept it, whether we need to communicate that acceptance or if there's a deemed acceptance after a certain period of time. And then if that product is not acceptable, are we sending it back to them? Are we destroying it? Are we able to keep it and maybe use it for some other purpose? And so here you'll see that we've set an acceptance period. The buyer, once they've received those goods, they have 10 days to look it over, make sure that it meets the specifications, and they can send a written acceptance to the co-manufacturer before that 10-day period. If they go the full 10 days without saying anything, it's just going to be deemed to have been accepted. And then we've got the rejection process, whereby we can reject that product without going to litigation, without having to go further down that dispute line, because we've dealt with it on the front end here in the contract. And representations and warranties. And here again, with the specifications, we want to bind the other party to the obligations that they're going to perform for us. So we've said what they're producing, we've said how we want them to produce it, and then we want them to also represent and warrant that they're going to produce them in accordance with applicable law, and that when they're delivering them to us, they're going to deliver something that is merchantable, something that we can sell, because ultimately that's our end goal, and something that's fit for its intended purpose. And fitness for its intended purpose, because we have communicated to them our specifications, they know exactly why we are engaging their services. We're relying on them and their expertise in production because we, as the buyer, we just had this idea, we just had this recipe. We don't know anything about large-scale production. We're relying on their expertise to get us where we need to be. And if they aren't able to do that, then we want to be able to pursue them for damages. We want to be able to pursue them for a breach of this provision.
And I think that's great. These reps and warranties are really important. While we want to avoid litigation, if you do need to litigate, you want to create the contract so that it's really easy to say you breached here, right? We've got everything laid out. This says exactly what you need to do, what you're repping to, what you're warranting. If you don't have it in your reps and warranties, it's harder to claim breach of contract because now you've got to fit it in, shoehorn it somewhere where it may not fit. So you want to think through these really carefully in regards to what is really important to your goals.
And indemnification and insurance, and this slide here is just indemnification. I did want to call out, I know there's a lot of text on the screen. I don't expect you guys to read all of this. If you do want these slides afterwards, please feel free to ask for them. We're happy to send them out. But I do just want to highlight various items from these provisions and give you guys a good look at what these will look like in an actual contract. And indemnification is one of the most important provisions in an agreement because it is going to determine how litigation will play out if and when a dispute arises. And so here we've got three different sections. We've got the co-manufacturer's indemnification. So this is saying what they're going to indemnify us for, And indemnify here means if there was a third-party claim against the buyer, indemnification would cause the co-manufacturer to pay for the buyer's legal liabilities that would arise out of that claim if it is in the scope of this provision. So here we've got the co-manufacturer is going to indemnify the buyer for a very broad range of items. It's anything arising out of, relating to, resulting from any claim of a third party occurring in connection with the finished products. And we want this to be very broad here because, like we said, the co-manufacturer is in the best place to avoid those liabilities down the road, right? They have the expertise and the knowledge in producing large-scale products to avoid product recalls, to avoid getting people sick, all of those various items. So if that does happen, we want to hold them liable for it rather than the buyer. Intellectual property indemnification, as I said, intellectual property is one of the most important assets for a startup. Here, we want to ensure that the buyer is not going to be liable for the intellectual property infringement of the co-manufacturer. So we're telling the co-manufacturer our specifications, we're providing them our recipe. If the co-manufacturer goes off book, if they use somebody else's recipe, the buyer shouldn't be responsible for that because they weren't in a position to stop it from happening. And then the buyer indemnification. So this is going to flow both ways in this agreement. Not always. Sometimes you have unilateral indemnification, but oftentimes a mutual indemnification is just inherently fair, and the parties can sort of agree on that. And so the buyer is going to indemnify the co-manufacturer if the buyer is going to take some action that causes a third-party claim. So if after the buyer receives that product, they do something to adulterate it, which causes somebody to get sick, say, the co-manufacturer shouldn't be responsible for that, obviously. And the buyer is going to step in and take over there. I'll touch briefly. There are a few different terms that are used in indemnification provisions. You'll often see defend, indemnify, and hold harmless. Indemnify and hold harmless are generally thought of as the same. There is some nuance there, but it's not really important for our purposes here. Defend is a unique obligation. So indemnify, they're going to pay for our legal liabilities. Defend means they're actually going to take over the defense of our legal liabilities. So we're getting sued, but the co-manufacturer is going to hire its own counsel, and they're going to represent us in court.
As Jason mentioned, indemnification is one of the most highly litigated provisions that we see in court. I think this for a couple of reasons. One is it's really dense and sort of hard to understand, and I think a lot of folks just sort of skim over it when they're going through a contract, so they're not entirely sure what's covered when a lawsuit arises. Hopefully it never does, but if it does, more likely than not, indemnification is going to come into play if there's a third party involved. So it's really important to know what's covered, what's not, what's under this scope, what isn't, so that when you get there, you're not first litigating over the indemnification provision, which is often what happens. So before you even get to the merits of your claim, your breach of contract claim, you're arguing and fighting and spending money and time over whether indemnification is required or not. So to avoid that, you want to read that provision before you sign your contract. You want to know what's defined expressly, what liabilities are covered and what are not. So is IP going to be covered by your indemnification provision or not? Is it expressly excluded from it? That's something you'd like to know. You want to know what triggers indemnification. When does it start? Is it a lawsuit? Is it a demand letter? What gets it started? When does somebody else have to pay for your legal fees? You're very quickly going to want that payment. And finally, what benefits flow? Is it covering attorney's fees? Is it going to cover damages if there's a judgment against you or a settlement? Is it going to cover a settlement agreement? Is it going to cover litigation costs, which are different than fees? So fees are the lawyer's time. Costs are your filing fees with the court. If you're in arbitration, the cost of your arbitrator, the cost of an expert witness. So there's a lot of other costs involved that aren't covered under attorney's fees.
And we'll talk about insurance here as well. And so insurance, I think it's important to understand that not everyone is going to have insurance. Oftentimes small businesses forego insurance. It's just not an expense that they can take on at an early time. However, insurance really does benefit both parties to an agreement, both because, the party who is maintaining the insurance is going to be covered in the event of one of these issues, and the party that is requiring them to maintain the insurance is going to have somebody to rely on to pay them in the event a dispute arises. The insurance agreement, or the insurance provision here that was in this co-manufacturing agreement, I wasn't particularly happy with. It was negotiated. Some of these items were cut. So you can see it's very bare bones. We've just stated the policies that they're going to maintain and the policy limits that they're going to have. And in determining these policy limits, we had the co-manufacturer go out and speak with an insurance agent to discuss what was appropriate here, what could they afford, and then we incorporated those into the agreement because we didn't want to put an obligation on them that wouldn't be appropriate here. Obviously, as a lawyer, I don't know how much insurance they should be maintaining, but somebody more expert in that will. But other things that I would want to see in an insurance provision, first, certificates of insurance. If we're requiring somebody to get insurance, we want them to provide us a copy of that certificate just to document that it is there, and now that we have a copy of it, we have all the information, we can contact the insurance company directly in the event that a case arises. Additional insured. We want the party that's maintaining the insurance to have to list us on the insurance as an additional insured. And so that would be on the certificate of insurance as well. It would cover co-manufacturer, and then it would also cover buyer. And that's important because we want the buyer to be directly covered by that insurance. We want them to be able to receive payment directly from the insurer. And then a waiver of subrogation. And so when an insurance claim happens, the insurer is going to step into the shoes of the party that is being insured. We don't want the insurer to try and sue the buyer for any kind of misconduct that they're going to allege gave rise to the claim. And so a waiver of subrogation is going to prevent the insurer from doing so that when the insurer steps into the shoes of the insured party, they're just going to have to pay out the claim or fight or pay for the defense. They're not able to go after the buyer in that instance.
Good. And having insurance is super important, but equally important is letting your insurance company know when a claim may have arisen. So I have a client right now, a company who's having a dispute with their employee, and it started about a year ago with the employee reaching out and letting them know, making a demand on the employer. Now the employer is a very nice and kind person, group, and they thought, oh, we can just work this out. This will never go to litigation. We'll make it go away. We'll give them what they need. Now a year later, it hasn't. They filed a complaint and hired me, and I said, okay, go file a claim with your insurance company. They did, and insurance said, it's too late. This has been going on for a year. We're not going to cover this. So while step one is having insurance, step two is telling your insurance company when you think there might be a claim. It does not have to be a complaint that's been filed.
All right. And force majeure. Force majeure is a provision that became incredibly important during the pandemic. You'll see, we can tell that this provision was written prior to the pandemic because it doesn't include an express pandemic or epidemic COVID-19 mention in here. And so what force majeure is doing is it's laying out a series of scenarios in which non-performance by either party is going to be excused. And it's going to be excused because some event occurred that was out of that party's control. So, here we have listed, these are serious events. They're fire, flood, storm, strike, lockout, labor trouble, riot, acts of war, acts of terrorism, rebellion, acts of God. And so this is a huge list of things that one party can't plan for and they can't prevent. And when they happen, they just kind of happen. So we don't want to hold either party responsible in those instances for performance when they physically and technically cannot perform. So here, this is especially important for the co-manufacturer. If the buyer obviously wants these goods to be produced, but the co-manufacturer is experiencing, a flood in their area and their facility is unable to produce, they shouldn't be held liable in that instance. However, it is important, and this is important from the buyer's end, that we state how long non-performance can go on before we're just going to call it quits and we're going to find somebody else to perform. And so here you'll see, I think we have a 60-day period where if non-performance is ongoing for 60 days, we're just going to go find somebody else and we're going to call this termination or this contract done. With that, I see two different ways of going about this. Oftentimes it's continuous non-performance as here, so 60 days of continuous non-performance. Sometimes it is a number of days of non-performance within a given time. So, 90 out of 120 days they're unable to perform. Then we're going to consider this contract done. And a limitation of liability. And this is huge to have on the front end. This is something that the co-manufacturer pushed for. This was a heavily negotiated provision. It often is a heavily negotiated provision in any agreement because it does severely reduce one party's recourse against the other. And so there's two different paragraphs here, and there's two different ways that liability is limited generally. The first paragraph is a limitation on certain types of damages, and so you'll see those listed out there. We have consequential, indirect, incidental, special, exemplary, punitive, and enhanced damages. And all of those are terms of art relating to various types of damages that one party could seek against the other in court. We're saying that they're not able to go after those. The only damages that you're able to pursue are actual damages. So it's the actual monetary harm that the party has suffered. That's what they're going to be able to recover. And then the second paragraph is a cap on the total amount of damages. And so there's often two different ways that this is provided. Either it's a flat dollar amount, so we'll say they're not going to be liable for anything over $1 million. Or, as it's done here, it is an aggregate of the amounts that were paid to that party in a given period of time. So here it is 12 months immediately preceding the event. So anything that was paid to them in that 12 months, they're going to be liable for up to that amount in the event of a claim. Now, the negotiated part here, and this was important for the buyer to get, was the first phrase, except for liability for indemnification, liability for breach of confidentiality, or liability for infringement. And that's important because we're carving those out from this limitation of liability. So if we have an indemnification claim, we're still going to be able to go after the co-manufacturer for an unlimited amount of damages, as well as any of those other types of damages. And so we've narrowed the instances in which this limitation of liability is applicable, and that's important for the buyer in this instance.
And so this provision goes to the third category that we talked about at the beginning for how to mitigate risk and how to avoid litigation, which is limiting the damages, capping your damages. If I think my damages could be $1 million, I might risk spending $200,000 to litigate it and go to court. But if I know my damages are capped at 12 months, let's say it's $1,000 a month that they're being paid. So now my damages are capped at $12,000. Well, I could spend $12,000 before we've ever even met the judge, easily. So it will encourage the parties to seek a settlement, an amicable resolution to the dispute when they both know that there's not that much at stake and they're more likely going to pay more than they could get.
All right. Now we're going to move to the development agreement, and we'll focus on some different provisions that are in the development agreement. But to start off with just context setting, again, recitals, why are we here? Why are we making this contract? And so here we have a company that wants web design services. We have a contractor that is able to provide those web design services, and so they're going to agree to these terms and or engage in this contract.
And again, as Jason said at the beginning, these recitals are not binding, but they are important to talk about because they help the parties to make sure that they're on the same page as they enter the contract. Are they seeking the same things? Do they understand what each side wants? It just helps get that dialogue going that can sometimes be overlooked as folks kind of dive into the nitty-gritty details right away.
Yeah. And so this was a master service agreement, and so what that means is that we have one larger agreement that's going to have some general terms, and underneath it we're going to have statements of work that set forth more of the business terms, more project-based. I want you to do this time. Once they complete that, maybe we have another project. We're going to have another statement of work. We want to have those business terms very hashed out, as Amanda said. Important to know, have that, we call it a meeting of the minds, make sure we're not talking past each other, so that each party understands explicitly what they're being asked to perform. And term and termination. And so term and termination are obviously very important. You want to know how long you're engaging in this contract for, and what is your ability to get out of it if you need to versus if you have to. Or rather, if you want to versus if you need to or have to. And so term here, this is relatively common. This is an auto-renewing term. And so we've stated that there's an initial term of 3 years. And once that initial term is over, it's just going to automatically renew for an additional 3 years. With a master service agreement, that makes sense to have an automatically renewing term. 3 years is a little bit on the long side. But for this instance, this was a long-term relationship. They were looking to work with these people for pretty much the duration of their company. This was an ongoing relationship. And then underneath that, we've got termination for convenience. And this is the termination if you want to. Here, we've got a relatively easy termination provision. It's just notice up in 30 days, and then you're out of it. And so that's easy for the parties to go their own ways. and then termination for cause. And here we want to be explicit about when things are going wrong, what are those things that can go wrong, which would allow us to simply end the relationship immediately and walk away. And so we've stated each of those explicitly, what constitutes a breach, what constitutes a default, and then next we're going to talk about the effect of termination, because whether that termination is for cause or for convenience, we want to be clear on what the parties' obligations are after termination. What are they going to do? Obviously, with an ongoing relationship like this, with most third-party agreements, there are things that need to happen after termination, and we want to be sure that the parties are clear on those. So, oftentimes you're going to give that third party your confidential information. We want to be clear on what they're going to do with that after termination. Are they going to destroy it? Are they going to return it to us? Are they going to store it for us? Various things like that. We also want to know that those indemnification obligations are going to survive that agreement. Various other items in the agreement that need to go past termination are still going to be applicable.
As you can see, we've devoted 3 slides to term and termination. It's an extremely important provision. We have a client right now who has a huge contract with a hospital, I think worth $4 million. The hospital decided they wanted to terminate it. Our client didn't realize that the termination provision allowed the hospital to terminate with 7 days written notice. So they left $3 million on the table that they'll never get because of that termination provision. And this leads me to another really important point. Always read your contracts before you sign them, please. I have litigated 2 cases just this year where the client didn't read the contract and the argument, but they signed it, and the argument in court is, Judge, I didn't read it, so I didn't know this was in here. And as I'm sure you can imagine, judges are not very sympathetic to that argument. It's not great when that's your best thing to say in court. So please read them before you sign them, so at least you know what you're up against. Excuse me, what your termination provisions say, when they can terminate.
All right, and restrictive covenants, these are often just called non-competes. I'm going to talk about non-competes generally. Non-competition law in Colorado just changed. Amanda's going to touch on that specifically, as that's going to be applicable to most of you. But more generally, restrictive covenants come in 3 flavors. You've got non-solicitation of employees, and non-solicitation of employees is kind of the odd man out here because the courts do not view a non-solicitation of employees in the same way that they view the other 2 with regard to customers and just a general non-competition provision, meaning that non-solicitation of employees is generally more enforceable. And really all we're saying here is that, while we are engaged with you as our contractor, and then for a certain period of time after we terminate, you're not going to poach our employees. You're not going to hire them on for yourself. And, this may be mutual. We may agree not to do the same thing for you. But it's really just saying that because we're going to work so closely together, we want to be sure that we maintain our business and our employees as ours, and you do the same for yours. And then a non-solicitation of customers, again, less enforceable oftentimes, just stating that they're not going to go out and try and poach your customers, again, because of the position they're in with access to your confidential information. That's a privileged position where they would be able to have that direct contact. We want to prevent them from doing so. And then non-competition, more generally, just stating that, we're engaged in XYZ business. You're a contractor that we're hiring on for this specific project. You're not going to start also doing XYZ business to compete with us.
These are one of the most highly litigated provisions that you'll see in a contract, maybe even more so than indemnification. In large part, it's because up until very, very recently, these provisions have been very loosey-goosey as to when they apply and when they're enforceable. And as we've talked a lot about, the less specific and defined something is, the more likely it is to be litigated. We also have in our country the idea that we don't want to put a restraint on trade. We want to allow businesses to freely flow, move, compete with one another. That butts up against this idea that we want to stop folks from stealing a company's proprietary information, their trade secrets, and go out and then compete based on having that information. So, non-competes are often the source of litigation, as are non-solicits with customers. The scope of such a provision must be limited in geography and duration. So the type of provision you'll often see is Jason, who was my employee, signed an employment agreement that says that during the scope of his employment and for 2 years after, he's not going to engage in the business that we have together that's got secret information, okay? It's got to have something trade secret, something confidential and proprietary. Maybe it's my customer list that I've spent years putting together and that I've given him access to when I hired him. Maybe it's that recipe, that secret recipe for the co-manufacturing agreement. Whatever it is, I don't want him going out and stealing it and starting a competing business with me. So 2 years in Denver. He can't start a competing business in Denver for 2 years. Up until recently, that would probably be enforceable. On August 10th, 2022, the law changed. Non-competes are now only enforceable against highly compensated employees, which for this year is $101,250. So if you make $80,000, you can't have a non-compete that's enforceable against you. Of course, the same condition applies that the purpose of the non-compete has to be the protection of trade secrets. Customer solicitation, so the non-solicits for customers, are similarly limited to employees making 60% of the highly compensated threshold, which for this year is $60,750. These must be clearly defined, and they can't place an undue burden on the employee. So that's always going to be a key point, and I think will maintain there to be a lot of litigation still going on around these provisions, but it likely will decrease. One thing to note, if you yourself have signed a non-compete or you have employees who have signed them prior to August 10th, 2022, this law is not retroactive, so the old laws will still apply, which means they are much more enforceable, but also much harder to define and could lead to litigation more easily.
And then confidentiality and proprietary rights. And so here in the development agreement, we've just called out we have a question. Yeah.
I think if you're so this question was, is it only for salary or salary and commission? My guess is it's probably not a black and white answer. If you're a fully commissioned employee where that's your only way you make money, I think it's hard because maybe you make $103,000 one year and 1 year you make 90. So my guess is it's probably going to be a pretty fact-specific inquiry by the courts at that point. If you're routinely making $200,000 or $300,000 a year, more likely.
Yeah. And I'd add in there, we're still waiting on a lot of guidance to come out with regard to this change in the law. They've kind of just given us this one piece of information. There hasn't been any further guidance, although there has been some promised. And so we're all kind of operating in a bit of a gray area while we wait for that to come out.
Yeah, and that often happens when labor laws change. Yep. The Labor Department is a little slower to issue guidance on how those will actually take effect.
Oh, and so confidentiality and proprietary rights. In this development agreement, we're just calling out here that's going to be dealt with in a separate agreement. We're doing that because it can make this agreement far too long. We want these things to be more digestible, more readable, but also we want to bind them separately to these confidentiality obligations so that if a claim does arise, we may be able to enforce under both of these agreements. We may be able to enforce under one of them. And so we're just going to jump into that now, the Proprietary Information Assignment Agreement, or PIAA. And the PIAA deals with two topics. The first is confidentiality, and the second is the assignment of work product. And so confidential information, what's important in a confidential information provision is how you're defining confidential information. The more tailored that we can make this to the actual information that you are disclosing to the other party, the more protective it's going to be, the more enforceable it's going to be if we do have to litigate. So you'll see here, this definition is relatively broad. But things like in the co-manufacturing agreement, there we were sure when we were defining confidential information to include those recipes that he was disclosing because that is really the asset we're trying to protect. And I think it's also important to note that confidential information here includes trade secrets. And trade secrets is a bit of a loose term of art, but generally what it's referring to is those things which are so fundamental to your business that they're never going to become public. So I think the easiest example is Coca-Cola's formula. It's something that they keep under lock and key that they don't share with anyone unless there is an actual need to know. And so you want to know what those things are for your business so you know how you're treating them. Because if it is going to be a trade secret, you want to have it maybe in a password protected document. You don't want to disclose it openly to whoever asks. It really needs to be just those people that need to know.
Great. And one thing that's important is the business owner or the person who's working on behalf of the company with the lawyer to draft these contracts. You know your business so much better than the lawyer does. So I know we always try to call out for our clients, like take a careful look at the definition of confidential information and be sure we've included everything in there that's important to your business. But I would just urge you to always do that because the lawyer won't always know, oh, the financial statements are particularly important to this business or the recipe or whatever it may be. And if it's not in there, if it's not part of your defined confidential information, it's not protected.
And so I'll just talk about this provision briefly. Disclosure and use obligations, we're just setting forth what they can and can't do with the confidential information we're giving them. We want to be explicit here. Obviously, we want the parties to know what they're doing. So if they're going to give it to some of their personnel, are we requiring those personnel to be bound by similar agreements of confidentiality? Are they allowed to share it with subcontractors? Various things like that. And then the duration of the confidentiality obligations. And this is where the distinction between trade secrets and confidential information more generally comes into play here. We want to establish how long they're going to keep this information secret for. This can be indefinite, but oftentimes that is too burdensome or considered non-enforceable. So confidential information, just that general confidential information, which does not constitute a trade secret, we're going to say that they're going to keep that confidential for the term of the agreement, and somewhere between 3 to 5 years is pretty typical after termination. But trade secret information, because the person disclosing it is never going to make it public, they're also never going to be allowed to make that public. We're going to say here that that trade secret information, that is an indefinite obligation to keep confidential. And then the second half of the PIA is dealing with assignment of work product. And so again, in a similar way to confidential information, we're going to define what work product is. And so you'll see that in that first paragraph, we're just stating generally that, the tangible medium that they're producing here for the development agreement, the code, the website, any materials that they did in the production of those two, that's all going to belong to the company that's paying for it. And then work made for hire. This couples with that first provision as to, we're stating generally that we're paying for it, we own it. Work made for hire is a term of art stating that certain types of work product, which is copyrightable, is considered automatically assigned to the party that is engaging the person for that work. And so we want to be sure that any of that work product that falls into that category of work made for hire is going to be automatically assigned under that provision of the Copyright Act. And then a few other items that are important to have when you are signing work product. Further assurances. This is just stating that, we as the company that's engaging you for this work may need to enforce our rights as to the intellectual property down the road. We may need to file for a trademark. We may need to file for a patent, something of that sort. And we may need the original author's signature on some kind of document. We may need their permission to do so just to establish that we are now the owners. And so we want them to be obligated to sign that document if we put it in front of them. And then further, because that contractor, we may be unable to find them. This may be 5 to 10 years down the road when we need them to do this. We want them to agree that we're going to have a power of attorney so that we can sign on their behalf if we can't contact them or, if they go out of business. And then moral rights. And so this is another term of art. Artists, when they create an art or any kind of creator, have moral rights within that piece. And this can give them certain legal rights as to how that is used even after they've sold it, even after they've assigned it to you. And so it's important that we state explicitly that they're going to waive those rights and that when we own it outright and we can do whatever we want with it. And then the no license. We're just stating generally that, they're making this work for us. We're not giving them the license to use any of our product.
And here I just want to talk about 3 provisions that you'll often see towards the end of your contract that we didn't talk about yet, but I just want to make sure you're aware of them. Like I said, read your contract from beginning to end. At the end, there's often a miscellaneous section, and I think folks tend to skip that part because they think, oh, these are the boilerplate provisions, they don't mean anything, I don't have to take a look at those. These can contain some really important provisions that are just important to know what you're getting into. So for example, a jury waiver. Unless you have a jury waiver in your contract, you're entitled to a jury. Everyone is entitled to have a jury. So, right, that's your 6 or 12 jurors who are going to be deciding your case. If your contract has a jury waiver, your case will be decided by a judge. And that's okay. It's just important to know. For some cases, it's better than others. You want to know what you're getting into. Arbitration. I see so many folks with arbitration provisions call me, they want to sue whoever, and I say, well, you've got an arbitration provision, so you actually can't sue them in court. We can arbitrate. And they say, what is that? So it's just important to know what it is. Arbitration is a private alternative dispute resolution. It's not in court, and it's not public. Everything that happens in arbitration is private. Otherwise, it's quite similar. It's a little more informal. The arbitrators are typically retired judges that the parties have to pay for. So remember, we talked about fees and costs. The arbitrator would be a cost. In contrast, if you're in court, your judge is paid by taxpayer dollars. We're all paying the judge's salaries all the time. You as a party are not responsible for that. So there is going to be an added cost if you arbitrate. And again, it's going to be private, which for some cases can be tricky because the media piece of a case can sometimes provide a lot of leverage besides the monetary piece, right? A big company isn't going to want bad PR. They don't care if it's an arbitration because nobody's ever going to know. And finally, you're almost always going to have a forum selection provision, and this is going to tell you where the case will happen if a case occurs. So let's say we live in Denver, we're signing a contract with someone who lives in Missouri, and they put a Missouri forum selection provision in their contract. That means that if there is a lawsuit, if I sue them because they breached the contract, I have to travel to Missouri to litigate. I have to have a Missouri barred lawyer. I can't have my lawyer here that I always use in Denver. Most likely they're not barred in Missouri. So again, just important clauses to know, always heavily negotiated and always up for discussion. Just important to know what you're getting into before you sign it. And finally, I just wanted to talk quickly about how do we see conflicts arise? And there's a couple scenarios that I see frequently. Most frequently are friendly parties. Friends, especially in the startup scene, right? 2 to 3 folks get together. They've been talking about this idea. They were kicking it around in business school. They graduate. They decide to start this company together. Oh, we're going to be friends forever. We never have to worry about what happens if we break up. Well, then you don't get your operating agreement in place. You don't talk about it. Maybe it's 2 people. What if you guys have different ideas and you can't agree? How does the company get split up? These get really messy. They get really emotional, and they get really expensive. So just like if I was a divorce attorney, I would always advise folks to have a prenup. If you start a business, I would always advise you to think through all the various ways it could end and how to deal with those. I think Jason and I have both seen in our experience, folks who do that on the front end not only pay a lot less on the back end when there is a breakup, but they often can remain friends that way and maintain the relationship. Another thing I see a lot is rushing to close the deal. Folks are just so excited to get the deal done. Maybe they feel some time constraint. Maybe there is. Or maybe they just are so excited. They just want to sign and get started. They're so excited to start making this food. Take your time. There's always another few minutes to review a portion of the contract. Read it, please. And negotiate the terms that are important to you and your business specifically. Other issues are undefined performance terms. So a lot of times you'll see a party will make their best efforts. What does that mean? Nobody knows. A court doesn't know. It's going to be a highly litigated type of provision. And then make sure your post-closing items, again, are just laid out clearly. Once the contract is done, everybody's achieved their goals, there's typically some things that still have to get done on the back end. Just make sure they're laid out in the contract. And what happens if they don't get done? And with that, thank you so much for attending, everyone. We have some time for questions, if anybody has any.
About the development agreement and the statement of work, with a lot of the industry moving more towards MVPs with featured add-ons rather than a set statement of work, how does that change the contracts?
I often see, and so the question is whether master service agreements with statements of works versus MVPs with add-ons are kind of the trend here. And I think oftentimes the MSA with the statement of work kind of structure can fit that. Generally, if those things are going to be project-based, they may have smaller statements of work, or you may just, it's about, I think, managing that relationship with the developer, kind of how much contact you want to have. And oftentimes, that can be covered in the MSA with various, provisions as to Are we going to have a weekly meeting to discuss add-ons and various things like that? Who's going to be the contact person more generally? So, yeah.
My name's Charlie, co-founder, CEO of Green Foods. We make the best hot sauce ever.
Cool.
Uh,
Best hot sauce in the back.
yeah, best hot sauce. And I've been in my business for a long time, 8 years, and I've had to go through a lot of contracts with banks and with bigger corporations. And it feels like, sometimes or often the terms are not very favorable for you, and you try to kind of push back on them, like, that's what our lawyer said. Like, do you guys have any suggestion for, like, is it really possible even to kind of get any terms changed with those bigger companies, or is there a good way to go about doing that?
Yeah. So I would say it never hurts to ask. Obviously, it's going to depend on how much leverage you have in the situation. If you're a small party trying to negotiate with, a large party, generally they're going to have a standard contract and they're not willing to waiver. And at that point, you kind of have to consider whether you're willing to agree to those terms in order to be able to use that larger provider, or if you want to look for somebody who's in a similar situation, maybe they're also a startup production company that would be more willing to negotiate with you on something mutually agreeable. I would also say, and this is definitely self-serving, but having an attorney helps to be able to communicate to them directly and say, I know that's what your lawyers are saying, but this is also what my lawyers are saying, that this isn't going to work for us. So that if they really want your business, they're going to have to change. Anything you'd add?
Yeah, I think that's right. And I'll add on, I always say that hiring a lawyer on the front end to help you negotiate your contracts is kind of like buying an insurance policy. Like, you hope you never need it, but if you had a lawyer on the front end, you're way less likely to have to litigate on the back end, and litigation is so expensive. It's very worth it. Did I see a question over here?
Yeah, when would you recommend including like an arbitration policy?
So I recommend arbitration in a couple of scenarios. One is if you are a bigger, more public-facing company where PR is going to be really harmful to you, then arbitration makes more sense because it's private. It's also typically a lot faster. So litigation, from filing the complaint, let's say everything goes smoothly and exactly right and you never have an extension of time, it's going to take at least a year, maybe 2, but typically more 3-4 years to go to trial. If there's a time sensitivity to the type of work you're doing, if you need to get things resolved more quickly, arbitration is going to happen a lot faster, 6 months, maybe a year, but it happens a lot quicker. Otherwise, I really don't encourage arbitration. Folks think it's less expensive, but it's honestly, in my experience, not. It's the same amount of work, you're just condensing it into a shorter period of time. So you're going to spend more money per month, but for fewer number of months.
We had another question.
When it comes to solicitation of customers, you mentioned that it has to have a geographic location. With so many businesses being like remote work only now, how does that work? So can you only do the location of your business, or if you have customers all over the U.S., can you say all over the U.S.?
Yeah, that's a really great question and something we're seeing a lot more. I have seen what a lot of businesses are doing is saying where we operate and where you've interacted with a customer in the past 12 months. So again, there's some time component limited. So if you've been at the job for 5 years and 5 years ago you talked to someone in Alaska, that's not going to be covered. But if you talked to them last week, you could probably get that in. So we're seeing language around that.
And I'd add there also something I'm seeing is there's that time constraint on when you interact with them. It's also that you directly interacted with them. It's not the employer's entire customer list that includes everyone, even folks you haven't discussed. Limiting it in that way makes it more enforceable. I've seen people push for that entire customer list, but it's with mixed results.
Yeah, great point.
On the friendly parties piece of it, I guess could you elaborate more? Is there any used example of friends you've known a bit? Maybe there's friends of friends, and there's all sorts of different scenarios in that realm of different levels of trust. But then there's also different needs of those people, of naiveness of certain parties and whatnot, to at least engage to actually have something, right? Mm-hmm. So I guess what I'm asking is, sitting down with whoever you're dealing with and hashing it, saying, hey, this is real and we need to do this.
Yeah.
Off the bat.
Yeah. I mean, obviously the latter is always going to be better. Oftentimes, when people are coming together to form a business, the first thing we have them do is we put together a term sheet for their operating agreement that's going to state exactly what their ownership is, exactly what their rights are, and it's also going to state exactly what happens if they want to break up, if they want to leave. That's generally the best situation, because then, 5-10 years down the road, one party isn't feeling it. We're experiencing this right now. We've got two friends that started a brewery together. The brewery is moderately successful, but one party has started doing things that the other doesn't like and wants to get out. They don't have an operating agreement. So now we're trying to negotiate something, but it's heading towards a litigation, which is obviously not where you want to be. So I always recommend sitting down, hashing it out. If you don't have an attorney, I don't recommend the operating agreements and various resources you can find on the internet. Oftentimes they aren't tailored to your specific situation, but you can get a
Can
general.
make it worse at the end.
Sometimes, but just sitting down and going over, this is what I own, this is what you own, this is our goal, and if this ends, we're going to try and do it in this way. And if you can involve a lawyer in that conversation, you're going to save yourself a lot of headache on the back end should the worst happen.
Speaking of conversations, do those have any weight? I mean, you're talking about conversations.
Yeah.
I mean, recorded conversation these days, there's a lot of Zoom calls, there's a lot of different things. Do those have any sort of precedent?
Oh, that's a really tough question. So in order to have an enforceable contract, you've got to have a meeting of the minds, which means the parties have to agree. So I would say it really depends on the nature of that conversation. If you and I are having a conversation and you say, if we break up, I think we should dissolve the company. And I say, no. I think if we break up, I'm just going to buy it from you. And that's the conversation. No,
Right.
that's not. But if we both, okay, yeah, if we have a recorded conversation that says, yeah, okay, if we disagree and we can't go forward anymore, we're going to dissolve the company and just split whatever's left. Yep, that's definitely what we're going to do. And you say, yeah, that's definitely what we're going to do. It's certainly evidence that supports your argument in court when you're saying that that's the way it goes. It is not necessarily, you can have a binding oral contract. If we say on that call, okay, and this is a contract, we're agreeing to it, that's probably enforceable. But now you're seeing how you've got to get really granular with the language. And again, by the time you're getting that in front of a jury in court,
Yeah.
you've spent so much more than you would have to put together that operating agreement or had that conversation and written some terms down on a piece of paper.
Yeah, and the goal is always to stay out of court.
Yes.
Obviously, right, you can have an enforcing oral obligation, but if you have to go to court to enforce it, you've kind of already lost.
Do you have any tips or resources for working on a retainer and what to look for and how they may be different than some of these contracts that you just talked about?
And working on a retainer with what kind of
As a designer.
as a designer? Graphic designer.
And
Oh.
long-term.
I think I would. Do you want to talk about retainers? I feel like you have personal experience with them.
With retainers, I mean, if you're talking about, so if you're the graphic designer and you start working with a new client and you want to take a retainer from them, I always recommend taking a retainer. I can't tell you, so Jason and I have been, how long has Milgram and Dascom been in existence? About 5 years. And when we started the law firm, we were like, we're not going to take retainers because it's so offensive to people and insulting and it's suggesting that we don't trust them.
And then we
Fi-
got burned like 1 or 2 times.
Plus another 1 or 2 times,
Yeah.
plus another 1 or 2 times, because you have to learn the lesson 5 or 6 times, is what I've learned. Now we always take a retainer. And I just explain to folks, this is why we do it. You know, if I think that they're going to be sensitive about it, I'm really sorry. What works for you? Oftentimes, like, I've got numbers for if it's litigation. If we're filing a complaint, I take no less than 5,000. If we're doing this, I can take 1,000. And I'll throw my number out and say, how does that feel to you? Does that feel like something you can work with? Because then that makes them feel like they buy it. And sometimes they'll say, that's a little steep for me. Could we start with 500? You know, and I might say, sure, that's fine. If we get to this point, I might have to up it, but sure, let's start there and see. A lot of times what I found is if folks are willing to pay a retainer, you're not going to have trouble with payment down the road. It's almost getting buy-in from them, like showing that they're committed to this project,
Yeah.
to this design work, whatever it is. So my personal opinion from experience is do it all the time. And if they don't want to pay a retainer, you probably don't want to work with them.
And then I'd say from the contract side, just to kind of document that as well, obviously you want to have in there that they're paying the retainer. Helpful things to have in there would be itemized invoices. You want to document how you're spending your time. If you're going to be billing them hourly versus project-based, when you're taking deductions from that retainer. Specifying how that retainer is being maintained. If it's in a separate account, is there going to be interest accruing on it? If there is interest, is that interest going to go to the customer, or is it going to go to you who's holding it? So you want to have all of those terms set out as well.
Yeah, great point.
Further questions?
Well, thank you all so much. Our contact information is up here on the screen. I think I speak for both of us that we're happy anytime to answer any questions.
Definitely.
Please feel free to reach out. There's some cards on the table as well if that's easier for you. Thank you all so much for being here today.